What would you do if a cop handed you a form, pointed to a line, and said, "Just sign here right now"? If you sign the wrong paper without asking one simple question first, your own signature can help them lock in a case against you. And the scary part is, you may think you're just signing a routine form when you're really giving away rights you still had. Hit subscribe right now because what you're about to hear could stop you from signing your way into a criminal case. Smash like too, because when you're nervous on the side of the road, you need simple words you can remember fast. You need to understand what's really happening in that moment. A pen comes out, the officer sounds calm, the paper looks official, your heart speeds up, and you just want the stop to end. That's when people make the biggest mistake. In this video, you're going to learn the first question you ask before your name touches anything. You're going to learn the difference between a ticket, a written statement, and a consent form. You're going to hear the exact lines that protect you when the officer acts like signing is no big deal. Let me show you exactly why one tiny signature can mean very different things depending on the paper in front of you. You'll also hear the court cases behind this in plain English, so you know what protects you and what can hurt you. If you ever drive, ride with friends, or get stopped walking, this matters to you. Here's the danger. You think a signature is just a signature. It's not. Sometimes it only means you got the ticket. Sometimes it means you promised to show up in court. But sometimes it means you just agreed to a search. Maybe you adopted a written statement or signed off on facts they will use later. Most people have no idea which kind of paper they're looking at when the pressure hits. And that pressure is the whole game. You want to be polite. You want to go home. You want the officer to stop staring at you. So you sign first and think later. I've analyzed over 200 body cam videos, and you see the same pattern again and again. The officer keeps it casual. The driver keeps it quick. Then later, that same quick signature becomes a problem in court. Here's the reality. Your first job is not to be fast. Your first job is to know what you're being asked to sign. The first thing you do is slow the moment down and identify the paper before you touch it. You do not guess. You do not assume. You do not sign because the officer sounds annoyed. You ask one clean question. Here's exactly what you say. What exactly is this document, and what does my signature mean? Word for word. Memorize that line. That question works because it forces the officer to define the paper out loud. If it's a citation, they may say, "Your signature only confirms receipt or promise to appear." If it's a written statement, now you know it is not routine. If it's a consent to search form, now the trap is visible. Watch what happens when you ask that question calmly. The whole feel of the stop changes, the pressure drops, the fog lifts. Now you are not reacting. You are making the officer explain what they are asking from you. This matters because different papers carry different risks. A ticket can often be handled later in court. A written statement can become evidence. A consent form can open the door to your car, your phone, or your bags. If you sign before you know which one it is, you're playing blind. You never want to play blind when your freedom is on the line. Defense attorneys use this exact line in court because it shows you did not blindly agree to anything. You asked for clarity first. That matters. Bad way. Most drivers say, "Sure, where do I sign?" Then they lock themselves into a document they never understood. Good way. Smart drivers say, "What exactly is this document?" And what does my signature mean? Then they force the meaning into the open before they decide anything. There is another reason this question helps you. It keeps your mouth safe. When people feel pressure, they start talking. They say things like, "I didn't do anything," or "I was only going a little over," or "I just had one drink." That extra talking can hurt you more than the paper. But your question keeps you focused on the document, not on defending yourself. That is where you want your head. Calm, narrow, specific. You should also understand this. Not every request to sign is dirty. Sometimes it really is just a receipt or a promise to appear. But your protection is not blind trust. Your protection is clarity first. You do not have to be rude. You do not have to raise your voice. You do not need a speech about your rights. You just need one question that makes the meaning clear before your pen moves. Think you could stay that calm with lights flashing behind you? Tell me in the comments, because this is the moment most people rush. Once you know the paper, the second move is to separate a routine ticket from anything that gives away rights. Here's exactly what you say. Am I only signing to confirm receipt or promise to appear, or am I giving up any rights? Those exact words. Keep them simple, keep them calm. Here's the trick they don't want you knowing. A lot of people here just sign here and assume every form works like a traffic ticket. It doesn't. A normal citation in many places is often not a confession. It is often just proof you received it. But other forms can do much more damage. A consent form can say you allowed a search. A written statement can make the officer's version of events look like your version too. A waiver can cut off arguments you may need later. That is why you ask whether you are only confirming receipt or giving up rights. This is 100% legal. You are allowed to ask what your signature does. You are allowed to know whether the paper is just an acknowledgement or something much bigger. Former police officers have confirmed this works because once you ask the question clearly, the officer knows you are paying attention. That alone can stop sloppy pressure. Bad way. Most drivers say, if it helps me leave faster, I will sign anything. Then they may sign a form that waives privacy or backs up the officer's story. Good way. Smart drivers say, am I only signing to confirm receipt or promise to appear? Or am I giving up any rights? Then they make the officer say the quiet part out loud. You need to hear this part very clearly. If the officer says it is only a citation signature required for the ticket process, you may have to sign depending on location. Refusing a required citation signature can sometimes make your night worse. But if that is what it is, you sign only that line. You do not write a little explanation. You do not add, I am sorry. You do not scribble facts into the margin. You do not turn your signature into a confession. You keep it tight and move on. And if the officer cannot clearly tell you what the form does, that should set off alarms in your head. If they dodge the question, rush you, or keep saying it is just routine without explaining the effect, you slow down even more. A routine paper can survive one simple question. A bad paper often hides behind speed and pressure. Here's the reality. The more the officer wants you moving fast, the more you should care about what you're signing. This comes straight from Supreme Court rulings about consent and waivers. Courts care whether you agreed voluntarily. They care whether you clearly gave something up. That means the meaning of your signature matters. A lot. So never act like a signature is just paperwork. It may be the cleanest evidence they get from you all night. The third move is what you do when the paper turns into a statement, an apology, or an explanation. If the officer wants you to sign anything that describes what happened, agrees with facts, or gives consent, you stop right there. You do not edit it. You do not fix one line. You do not think a small correction makes it safe. You do not sign it. You look at the officer and say this, I am not making any statements, and I want to remain silent. Word for word. Memorize that line too. Legal experts agree this is your strongest protection. Why is this so powerful? Because once you sign a statement, they can point to your own name under their facts. Maybe you were flustered. Maybe you misunderstood the wording. Maybe the officer summarized your words in a way that helps the case. It won't matter much later if your signature is under it. Your signature gives that paper weight. And once the paper looks like your adopted statement, undoing that damage becomes much harder. Bad way. Most drivers say, let me just fix one sentence and then I will sign it. Then the whole document still becomes part of the evidence against them. Good way. Smart drivers say, I want to remain silent. Then they stop turning paperwork into proof. This is not about being difficult. This is about understanding the difference between identification and self-incrimination. One is routine. The other is how you help build the case against yourself. If you are in a stressful stop, your brain is not at its best. You are not in a quiet room with time to think. You are not sitting with your lawyer. You are beside a road, under pressure, trying to get home. That is the worst possible time for you to sign a narrative. And there is something else you need to know. Silence works best when it is clear. Just staring at the paper is not enough. Shrugging is not enough. Mumbling is not enough. You use a direct sentence. You say you want to remain silent. Then you actually stay silent. No side comments. No, but let me explain one thing. No extra details. That last part is where people blow it. You may be wondering if this makes you look guilty. It can feel that way in the moment. But guilt is not decided by how chatty you are on the roadside. Guilt is decided by evidence, law, and procedure. Your job is not to look innocent by talking. Your job is to avoid harming yourself by signing or saying too much. Burghouse v. Tompkins teaches a simple lesson. If you want the protection of silence, say it clearly. Then stop talking. If you have made it this far, you are serious about protection. Hit that like button because the next move is where people get trapped by pressure and false urgency. The fourth move is what you do when the officer keeps pushing after you ask questions and refuse extra paperwork. This is the moment where tone matters just as much as words. You do not argue. You do not yank the paper away. You do not call names. You stay calm and pin the issue down. Here's exactly what you say. I will comply with lawful orders, but I will not sign anything else without a lawyer. Those exact words. That line does two smart things for you. First, it shows you are not resisting. You are not refusing lawful commands. Second, it draws a bright line around more paperwork. If it is something beyond a routine required citation signature, you stop. You are asking for counsel first. This is 100% legal. You have every right to avoid signing extra forms. Bad way. Most drivers say, fine, whatever, just give me the pen. Then the officer gets a fast signature and a stronger file. Good way. Smart drivers say I will comply with lawful orders, but I will not sign anything else without a lawyer. Then they stop pressure from turning into paperwork. Watch what happens when you use that line the right way. The officer has to decide whether the paper is truly required right then, or whether it was just something they hoped you would sign. That difference matters. If it is truly required, the officer should be able to say exactly why. If it is not, the push often fades once you stop acting confused. Let me show you exactly what this changes. Instead of you being the person who signs first and asks later, you become the person who makes the legal meaning clear. Now let's connect this to the law in simple English, so you know these lines are not just street wisdom. In Schneckloth versus Bustamante, the Supreme Court said, consent matters. If you agree to a search, that agreement makes it legal. That is why you never casually sign consent papers. In Berghus versus Tompkins, the court made clear you must speak to be silent. In plain English, do not expect anyone to read your mind. Use the words. In Rodriguez versus United States, the court limited stop duration. Police cannot drag a stop out longer than needed without real legal cause. They do not get unlimited time to pressure you. These cases all point the same way. Your words matter, your consent matters, your time matters, and your signature matters too. Now picture your own stop, so this gets real for you. It is dark. You get pulled over for rolling through a stop sign. You hand over your license and insurance. The officer comes back with a clipboard and says, just sign here. The wrong way starts fast. You don't ask what the paper is. You just want to go home. You sign. Then the officer slides over a second page and says, this one is routine too. You sign that one as well. Later, you learn the first was the citation, but the second was a written statement that made it sound like you admitted guilt. Now your own signature sits under words that hurt you. Now watch the right way. The officer says, just sign here. You stay calm and ask, what exactly is this document and what does my signature mean? The officer says it is the citation. Then you ask, am I only signing to confirm receipt or giving up any rights? The officer says it is just the citation signature. Fine. You sign only that line? Then the officer tries one more move. He says, sign this second page too so we can clear this up. You ask what it is. He says it is your explanation. You stop right there. You say, I'm not making any statements and I want to remain silent. If the pressure keeps coming, you use the last line. I will comply with lawful orders, but I will not sign without a lawyer. That is how you keep a simple citation from turning into your own written evidence file. Coming next week, I'm breaking down what to say when an officer tells you to unlock your phone. The officer claims it will only take a second. Subscribe now because that one mistake can expose your whole life. So lock these 4 moves into your head. First, ask what the document is and what your signature means. Second, find out if you are only confirming receipt or giving up rights. Third, refuse to sign statements, explanations, or consent papers that help build the case. Fourth, if the pressure keeps coming, comply with lawful orders, but stop all extra signing until you have a lawyer. You do not need a big speech. You need short lines you can use while your hands shake and your brain races. That is how you protect yourself when the pen comes out. Hit subscribe so you catch that phone search video next. Smash. Like, if this gave you a real plan, you can actually remember. And drop a comment telling me which one sentence you are memorizing first. Stay calm, ask first, and never let your own signature do their job for them.